It's 9:30. We'll call the Tennessee Collection Service Board meeting to order for July the 8th, 2015. Nicole, if you will please read the roll call.
Art Howard,
Present.
Steve Harb,
Present.
Chip Hellman, Elizabeth Dixon.
Present.
Sir, I believe we have quorum.
Thank you, ma'am. And would you read the notice of meeting, please?
The notice of meeting was posted, this July 8th, 2015 meeting of the Collection Service Board was posted to the website on June 29th, 2015. That's all that was necessary to read.
Postage, all you need to do, okay.
Yep.
And the agenda, will everyone review the agenda? Are none, I will accept a motion to approve the agenda.
So moved.
And seconded, all in favor? Aye. Okay. Minutes of the March 11th, 2015 meeting, we got those in the mail recently, and has everybody had an opportunity to read those? Are there any changes or additions to those March 15th minutes? If not, I'll entertain a motion to approve those minutes.
So moved.
Second.
Moved and seconded, all in favor say aye.
Aye.
Aye. Okay. Legal report, Ms. Beard. They're on my screen here.
Oh, yeah, I think on the agenda, the director's report is listed first,
Yeah,
but
but-
we can take it in whatever
Oh, I'm
order.
sorry.
It doesn't matter to me.
My,
That's the one you gotta look
my agenda changed since we got there. Okay.
There you go.
Okay. All right, let's do the director's report first. The agenda I got in the mail had it reversed. Y'all are just trying to fool with me.
No. No, I'm not witty enough to be fooling anybody this morning.
Okay. Well, let's do the director's report according to the technology that we have available.
Okay. On the director's report, I have posted for you the past 4 years' budget information, also the year-to-date for the expenditures and revenue. I have the license status counts as of June 29th, 2015 for the
Have managers?
according to the reports you do. I'm not certain if they're phasing out or waiting to expire, but that's, according to the reports, they're still out there. So,
Interesting. We're not required to have them any longer. So anybody who was a manager that was open as a manager is just kind of still one
I guess so.
because there's no renewals.
Right.
Was there ever a renewal for a manager's license?
I don't know, I can look into that.
Well, I mean, you don't have to do that.
I just pulled the reports and thought
Yeah.
I should show you what we
It's
had.
interesting, is it? Oh, okay.
The complaints per performance measures, that's a mouthful. We are currently 90% on time, so that's very good. And I have over 180 days in open status, 7 complaints. There are no legislative updates for this month. For the matters beginning on number 2, for the items that I need votes for, the North American Collection Agency Regulatory Association NACARA meeting will be held in Denver, Colorado, September 28th through 30th, 2015. With the board's approval, I would like to submit a request for the executive director and the board's attorney to attend this conference so that I may become more familiar with the collection agency regulatory requirements. Both Keeling and I want to submit a travel request for this. I'd like the board to vote on that matter.
A motion that we approve that request.
So moved.
Second.
Moved and seconded. All in favor say aye.
Aye.
Aye. Y'all have fun? No?
We want a good report.
All right. Subsequent to this report, you will see on your iPads a list of the voluntary surrenders that we maintain for you. It's just listed just subsequent to this director's report, so it's included. To improve the process of renewals for collection agency, administrative staff has developed a form for the board's consideration. There's a PDF fillable form. I'd like to take a moment for you guys to review the content to ensure we kept the content requirements that the board desires. We believe that allowing the administrative personnel to fill these forms out electronically will improve the delivery, speed, and quality of submissions to our office. Also, this form auto-calculates the financial information and indicates if the assets do not exceed liabilities. This may incentivize companies to consult with their CPAs before submitting incorrect or incomplete data, or at a minimum, prepare them to explain why their liabilities exceed their trust account reserves. I won't ask you to vote on this immediately, but I'd like for Cody to show you the information on his laptop, the form that we've developed.
Yeah, very briefly, I'll give you a quick look at what we've been working on.
Write it down, we'll all
Yeah.
bunch up.
To make sure that everything on here totals at certain points.
That's not as critical as some of your wording, actually.
Okay.
That's going to be confusing. I'll wait till you turn it. No, it's the wording that you took off the existing form, probably.
Well, we've tried to improve it, but I definitely would welcome your assistance or any
Biggest confusion
offer some.
falls into delineating the funds held in trust and then amount due clients.
So here's how. Ask that all the information correspond to the CPA created finance. But I'm under the impression that some of this information would not be included in that.
Well, trust account may not necessarily be broken out as a trust account on a
Right.
CPA prepared statement. It's going to be a bank account, and sometimes they'll consolidate bank accounts. If you have your trust account and an operating account at the same bank, they're just going to show money in XYZ bank or cash in bank. So it won't necessarily break it out because you have a trust and operating. Somebody will have to break them apart. So the total might total back to it, but it's not going to,
Sure.
may not match.
Well, this may be too simplistic.
Well,
Different kinds of agents.
It's more a matter of instructions and definitions. Total assets, total liabilities, assets minus liabilities.
Well,
Yeah, that's in the statute.
So I think the manager or the officer of this corporation has to know what.
Yeah.
I think what he's saying, the issue that we come up against is that we have
It's this phrase,
non-traditional.
all information must correspond to the attached statement. That means you have to be able to see it on the attached statement. And
Oh,
you
I
may
see.
not be able to see it on the attached statement. Now,
see what you're-
trust and operating added together might equal it, so you'll have to do math to verify it. But that's logical, but the manager will know trust from operating, but a CPA is gonna put cash in bank
I got
sometime,
you.
unless,
I see.
unless they delineate it on the CPA statement. And the other thing is accounts due to clients. More logically, it would be amounts due to clients.
Okay.
Amounts due to clients, that's gonna confuse people. Everybody thinks in terms of the accounts we have, and that's different than amount. It's a-
Amount.
Yeah.
Amount due to client is a lot better word.
Okay.
It's
Well,
gonna throw 'em.
I don't want to take up too much time.
What we're here for.
But we'll definitely be working on this, and I would love to be able to send you.
Actually, assets minus liabilities should equal total equity. That's gonna be, this is gonna make it even more confusing, because what you're looking for.
Organize the information to make sense
Yeah.
to the agency.
Because the best PDF file in America is not gonna.
You know,
Those
because
things.
when I had my agency, I made the mistake twice.
Question, is there some reason we can't put a page that explains what each account means? I know people are supposed to know stuff, but there's no instructions with our statements, our forms.
This is what we wanted to do. This is, if there's a way to communicate it, us the
Actually,
information.
If you actually just said, numbered these lines and say, see instructions, and then on the instruction page, line 1, this is what it means.
Yeah, that's the mentality.
Trust
we have.
account.
Good idea.
That's, just a simple couple of lines.
We're
And
trying to make things as
Yeah.
self-explanatory as possible.
Yeah. And perhaps he could help you and write this out.
No. You can write the instructions. They're in the forms. The trust account. This is the amount that you hold in trust. It's separate from your other cash. Duh.
Sure.
You know.
It should be simple enough that
Had to, yeah.
if we could show it to you
Yeah.
as we move through the process.
For the wording accounts versus amounts.
Yeah,
That,
just little things
that
like
is
that.
very confusing.
That I
Yeah.
wouldn't necessarily catch
yeah.
from
Be
the
glad
other
to look at
forms. Okay.
If I'm allowed to look at it outside.
Yeah, sure
no-
you are.
no, okay. As long as I'm not violating any weird little rules.
I actually have some hard copies printed out. Should we pass these
great.
around? Or?
I commend staff for trying to make things more efficient.
Yeah, we're a couple
Here,
weeks into
Steve.
it, and obviously we don't know all the wrinkles yet.
The renewals are obviously since they come in such large quantities,
Seems to take an
they're huge. We need to fix the initial applications because requirement for that 6-month operating budget. I don't think
Have a suggested application, and you brought it to us, I think would be great to look at that and pick, like, tickled to death to help you with anything we can.
We're learning as we go.
We want to try to make it as simple for people as possible, because that's one of the reasons why I spent so much time creating that report that's going to follow on the incomplete applications. And trust me, Kimberly, staff, me and Kimberly, like, we powerhouse through, I want to say, like, hundreds. All of these applications as cleaned up as possible, and still there's so many applications still pending. So got everything off that we possibly could, including files that had been missing. Ever to find some of these files. So we cleaned it up, and there's still some files that have been hanging out since January with no. That says we're not providing our applicants instructions, or we need to amend the rules to say if your application is in.
Haven't received a yes or no, then
Then we need to
balls
deny.
balls in our court, yeah.
You know, if you can't
Why can't you
come up
deny?
with the goods,
Why can't we deny it?
it does. I don't think, I haven't found anything in the rules that says after this much time.
If they haven't completed the application properly, then we can deny it.
Why can't we?
Back on the agenda.
That would be,
Legal on that.
yeah, I think I have to.
Yeah, I don't necessarily know that we would need a rule that says we can deny you if you don't complete it in this. I guess it's just sort of inherent in
Let's drop back for a moment. If it's not completed correctly, why can't we deny it?
No, you can.
We're being generous to ask them and ask them and ask them.
Right.
After we've asked them twice, if they can't get us the stuff we've asked for,
Right, if the
we have a
application is
duty
not
to deny it
complete,
because they're
then
too
you can certainly
stupid to do the
deny.
work.
Right. Right.
I mean,
I think that's a good point, that if we've asked them once or twice
Twice.
being the most, and they still don't comply, then we just deny their application.
or if they comply incorrectly a second time.
Yeah.
Sure, you ask them one time, I need this additional information. And then they send it to you wrong, and then you ask them one more time, and they still can't get it right, you have to say, do we want this person collecting in our state?
Okay. Well, some of that is what I'm going to come to in these next items, so is.
On number 4 of your report, Nicole, we'd, rather than a vote, I think we'll just table that until we've gotten some other information, or do you need the vote?
Oh, we can table that. Ms. Trinkler submitted an email to Ms. Whaley regarding information that the board may want to consider adding to the application relevant to the principals involved in the business. Please provide information that will satisfy the state of Tennessee's requirements for licensing expressed in 622107. Items 1, 2, 3, and 4. Items may include but are not limited to letters, references, resumes, education, experience, etc. I included that just behind the director's report. It would be it's
622107 mentions applicant. Is that for the licensee or the manager? Not sure how we would what person do we want this information about? What person do we want this information as far their resumes, education, experience?
Well,
If talking about a business or a company, then we have to also include somebody that's going to be running it, I suppose.
But the thing is they give us their resume. There's no actionable issue that I'm aware of that if we don't like their resume, what do we do about it? I mean, we ask if they're felons. If they lie about that, well, maybe a felon would lie about it. I don't know that we check it. But if they give us a resume and says, I didn't go to high school and I don't care, we're not going to deny anything. It's nice to know, but why have we wasted our time learning it? I mean, it's good information to have, but it's not actionable.
Well, and not only that, but upon whom is the information? Is it anybody that works there? Is it everybody that works there?
It's the principals. That's what she implied. The principals of the company, the people who own the company and or sign the
I
checks.
don't think our statutes allow us to ask that.
We can ask for it, but we can't do anything with it.
Right, I think that maybe what, I can't speak for her, but maybe what she was getting at was by asking to have these items included, it might help to make a judgment call on 6220-107 on those first couple of items regarding trustworthiness, honesty, and fair dealings. I think maybe she was thinking these would help guide.
And I think it's a good idea, actually, I do. Whether or not it's actionable, Steve, I think that she's got a point.
Right, maybe it's just some extra information that you could use as a guidepost to try to make the decisions as far as trustworthiness. Right. Like I said, I can't speak for her, but that's probably where she was going.
What I think she's saying.
Okay.
I definitely agree. When we did away with our manager requirement, it opened up to anybody that wants to get in the business can, and I don't mean anybody, we want everybody to be in business, but as far as recognizing those not qualified, I think we should be able to do that.
To not do that would be, we're just flying without radar.
Right, I mean, it's probably better to have more information than not enough when you're making a judgment call on someone's honesty or trustworthiness and things like that.
Or at least when something happens and a complaint comes in, we know who to go to.
Right.
The thing is, maybe identifying who to go to, but I really had a resume that starts out by saying I'm a jerk.
Right.
And so how are we going to tell from a resume or now, if we run a background check, we can find out if they're trustworthy. If we go out and if we started doing inquiries and, do nearbys and call relatives and inquire about them, but we're not really authorized to do that. So we're not investigating them. Again, it's nice to have the information, and again, on whom, but the question is it actionable? What are we going to do with it? And what can we ask the staff to do with it? To make a pure judgment call on trustworthiness, or we can ask for their personal financial statement. Who's the person that runs your collection floor? I want to see their personal financial statement. Have they ever been bankrupt? Now, if you've got a guy who's running the collection floor who's filed bankruptcy a couple of times, okay, you got something to talk about.
Well, but I don't think our statute would allow us to deny a license based on the collection floor.
It says, the collection service business shall be issued to any person. Now, to me, it's confusing whether it's a person or a company.
It's a company.
Companies are people in the eyes of the law. So has the company ever filed bankruptcy, or has the lead person or the owner filed bankruptcy? Maybe something we can ask. But it's the only thing that would tell us some of the things we're asking for, financial responsibility. But like you pointed out, Bart, who do we ask? The principal owner, the majority owner?
Well, we already asked who are the owners of the company in the application, don't we? And I don't know if we have authority to ask the principals. Not the personal information, do we have the authority to deny application based on that information?
That is definitely something to consider. We might need to just think further about this.
You read, service business shall be issued to any person. Now,
If you'd like, we could have and administrative staff work on some character questions and present them. That might help. If you think that that might help, at least then they'd be attesting to something, and if they were dishonest on an application, that gives you something to poke them
There
for.
you go. Yeah, I think we should ask that question of the principals.
Right.
And that's who we ask those.
As
ask those
opposed to collecting references, resumes, education, because I do kind of agree with you that you're going to get a resume or a reference from the people who like you. You're going to choose somebody, or your dad, or somebody who is probably going to say, yeah, they're great, we love them.
But-
And
The question, have you ever made a composition settlement or have you ever filed for bankruptcy?
but if you
And the
ask that
answer-
question,
that's
if
a
you
pretty
lie,
straightforward. Now, that's a yes or no question, and that could imply some trustworthiness for the collection business. Because you got somebody who's filed for bankruptcy or done composition settlements and they're out collecting. I don't know if that's bad. I mean, bankruptcy laws are not, doesn't mean you're a terrible person.
I think the point is that if they say, yes, I filed bankruptcy, can we deny their application?
That we should.
Oh, I don't either.
Doesn't mean they're not trustworthy, yeah.
I don't think so either, but it's just more information than we have. It's a little bit. Always had trouble with this section, you know, because it's really is more subjective than you would imagine it would be in rules and.
To me, this section is more for the use of revoking someone's license as opposed to granting a license. Because if somebody comes in here and they've had repetitive bad acts, this would give us grounds to revoke them because they've proven they're not trustworthy. They've proven by their bad acts with their people that they're not doing the right thing. And we can just come under this and say, you're out of here. But denying the license initially, I don't think we have enough room. But we ought to cancel a few more licenses than we do based on some of the acts I've seen.
I think, Nicole, if you could bring us some suggested questions that we would ask, what we do with the answers determine.
I think we have some language that we could use from similar programs that may advise or amend to this program, and it might, I think that
Number
6.
number 6.
We've received several applications, and by several, I'm actually being very minimalistic, applications where the collections agency was a subsidiary of a parent company, and the application would include the parent company's financial information. But when completing the required financial statement form, by the board about the trust account and the owed to clients, they are reporting on just the subsidiary information. I'm requesting direction from the board as to how you intend the rules to be interpreted as prepared financial statements. Is the parent company information acceptable? Will not allowing such be burdensome to smaller collection companies that will have to engage a CPA to prepare financial statements? Thank you for your guidance in this matter. There are examples. You'll see from the subsequent applications.
Yeah.
So we can go straight into the rest of this if you want to wait on that. I can read you more of the rest of it, because the rest is all applications, and we have several of these are parent subsidiary.
I just worry about them being able to use a parent subsidiary track of them that way.
Well, it's actually been reviewed inconsistently in just the month
Yeah.
that I've.
Yeah, I know
We
that.
we have 2 accountants on staff that have been working to help review applications. Kimberly Whaley. They're reviewing the financial piece. I'm reviewing the administrative piece of the application. So I'm financial data because I'm not an accountant. I tried, and it was immensely difficult to do it, especially keeping up with the amount that comes in. They breed like rabbits. A lot of these applications well, they come in and they're all different. Some of them, the application will be entirely about the parent company's financials. Some of them, the form, that's the state of Tennessee's form, will be the subsidiaries. They don't match at all.
You know, there's nothing wrong with just saying your application's rejected. I mean, just because they send us an application doesn't mean we have to be best buds with them. And we need to follow the entity. A parent, if it's not a disregarded entity, if it's an LLC and a part of a parent that's a disregarded entity, it shouldn't be producing financials anyway. But we have to hold the entity or the people that own the entity responsible. Got to be, in my mind, the information of the entity that's applying. I mean,
But what she's saying is the entity applies XYZ Corporation that may be a parent of several subsidies.
but I don't care about the parent. The parent's not
Well,
applying
I
for the
know,
license.
well, I know it, but that's the way the application is coming. So I think that we probably, in my, have to have an application on the agency, the one that's collecting the money for the client. We want to protect that client's money. As the company also sells automobiles, we don't want to use that profit from selling the automobiles to pay our clients in the collection business.
Right.
We have to make sure that they're financially sound and protect the citizens of the state of Tennessee. That's the ultimate responsibility. But we have to be flexible enough to make sure that we are encouraging small businesses to still be able to proceed with commerce in the state of Tennessee. So I think if you look at some of these applications, you'll see what's going on. But I noticed there was some inconsistency in how applications were being reviewed. One way and going into a great deal of effort to review the financial statements and dig through figure out how much the subsidiaries' money was, and I just want to know what the will of the board is. What if you guys can establish a policy moving forward of how to handle this? You know, thy will be done. But I need a policy. How administratively do you want me to handle this? And then I will handle it. But I need you to know what you want done. And then that's what we'll post it to the website. This is what's expected. This is how applications are going to be reviewed.
I think, and the board can agree or disagree with me, but I think that the entity election work should have its own separate financial statements and not include. Election agency needs to borrow money from the home office or the conglomerate, then that's one thing. But I think that the funds need to be kept separate.
Absolutely.
Okay.
I think that the fact that the parent is an owner is no different than he may be an owner or you may be an owner. We're not going to get your financial statement because you own the company.
Right.
If I'm the owner of a company and the company applies, you don't ask for my personal financial statement. Why do I want the parent statement? It's just the owner. It's not the company. We need to get the information on the company. And again, if the company can't get the information or doesn't have it, or if our rules aren't convenient for them to come into Tennessee and collect, then don't come and collect here.
Do you
Just you just say it, and we'll make it so. So
Okay, I would entertain a motion that we require agencies that are.
Make the motion.
I can't make the motion.
You can't make a motion?
He's stating what the motion is.
So you have to make the motion. That the, election in Tennessee must keep its funds separate from the parent company, keep it separate from the parent company and maintain separate financial. Second. You want to
Yeah,
amend the motion?
I would say it a little different, but that second's fine. Yeah,
All in favor, say aye. Aye. Okay. Number 7?
All right. Recovery Services International, number 520, submitted an application, renewal application, which is expired currently. Their application was received back in January of 2015. They did not submit the financial form signed by a CPA. There was subsequent exchange of emails in later 2015 where the Vice President, Mark Hirsch, indicated RSI is a wholly owned internal entity of ACE Group, and the financial statements are not prepared by a licensed CPA at that level. He indicated that the company was rolled up in the group's financials, which are ultimately audited by an internal CPA firm. He indicated they provided a certification page signed by the Chief Financial Officer for RSI attesting to the accuracy of the statement, which is what they provided in past years. That's a similar exchange occurred in late April with no resolution.
Did our previous motion answer that question?
okay, in this case, if I may, I'm interrupting you.
Go ahead,
This
pal.
kind of makes me a little angry, because what they're trying to do is create an entity so they can have a shield from any kind of liability and then not maintain that entity that complies with our rules. Well, why don't they just let the parent collect? If the parent got the license, we'd have no problem at all. They don't, because they don't want the parent to have the exposure. Well, they need to pay for their insurance policy. They don't get it for free. Let them follow our rules. I'd tell them absolutely not. A parent can get a license. It's an entity. If he wants to create a subsidiary to do collection, then create a subsidiary and follow the rules, or don't collect in our state.
I'd entertain a motion that we deny this request and require them to have a separate entity and a financial statement prepared by a CPA, just like our statutes say, and submitted at that time. I do think that we should give him the time that he needs to do that. I don't think that we ought to go off in here and deny his application right off the bat, that's too much of a motion.
I would suggest we ask them to reapply.
Yeah, reapply,
In correct format.
reapply in the name of the entity that's doing the collection effort, and this financial statement must be prepared by a CPA. Is that a good motion?
Art, I'd just simply say, we should deny their request and submit to them that they can reapply under the entity that's asking for the license. That's all we have to tell them. No,
There you go.
the entity that's asking for the license can apply. You are always welcome for your parent to apply for the license if it wants to collect in our state.
Is that the motion?
I'd move.
Second?
Seconded, all in favor? Aye. Okay. Number 8?
All right, Stonegate Mortgage, 1861, checked yes to character question 2 on the agency history information, which reads, have you ever been denied a license in Tennessee or any other state? And they indicated they were denied in Florida because their branch manager resigned during the application process. They stated they intended to reapply when a new branch manager is hired. They also answered yes to character question 4, which reads, in the last 7 years, have you had any type of civil judgment against your agency? They indicated a $5,000 judgment in Kentucky and a $500 in Connecticut. Relevant documents are attached. However, the director has a full application on hand at the meeting for your review if required. And that's over there next to Mr. Hart.
I'd like to move that we approve this Stonegate Mortgage if all their other qualifications comply, because they were denied a license in Florida because their manager quit is not a reason to deny them. $5,000 judgments in Kentucky and $500 in Connecticut are not reason, we don't have any reason
Oh.
to deny them based on that.
Do we know if the judgment was a trust issue or an FDCPA type issue?
It was an FDCPA issue.
If it's FDCPA, I'm surprised they only have 2 judgments.
Yeah, I mean,
Pretty impressive.
I read that and it's an FDCPA.
Okay,
case.
yeah. If it's a trust issue, that's a different thing, but no.
Is there a motion?
So moved.
Second.
And seconded, all in favor?
Aye.
Aye. Okay. Number 9.
Reliant Capital Solutions LLC, 1874, checked yes to character question 3, Part E on the agency history information, which reads, in the last 7 years, have you, do you now have any civil actions pending against you or your agency? They indicated in the matter involved an alleged violation of the Fair Debt Collection Practices Act. Documents from Oklahoma and California were attached for the board's review. The relevant documents, however, the director has the full application at the meeting for your review.
Got it on email.
Otherwise, it would be just an immense file.
I'd entertain that we approve this application if all the other documents meet the requirements of the statute.
Second.
Moved and seconded, all in favor, say aye. Aye. Number 10?
Can I make a comment?
Okay.
Generally speaking, if they're FDCPA suits, you don't need to bring them to us. But if they're suits based on trust or any other matter where there's any other kind of liability, but if they're FDCPA type suits, that is very common in our industry.
Okay, I wasn't certain, and
Yeah, well, you did the right thing.
But yeah, absolutely, it's the right thing. But generally speaking, under FDCPA suits, there are attorneys who make a business of filing those suits, because in the FDCPA, they can file a suit for $1,000 claim just because they feel like it. I mean, that's not exactly the correct terminology, but it approaches reality.
Well, agency has to pay attorney fees, that's why they file.
Yes. Then they charge attorney's fees, and so they settle the case for anywhere from $3,500 to $5,000 to $7,000, and the $1,000 goes to the person who sued, and the rest is attorney fees. Now, if you defend one of those suits, it costs $20,000 to $25,000. So that is a cottage industry against collection agencies.
I think when Steve and I first got in the collection business back in the 70s and 80s, there were a lot of bad apples in it. But they had, between the FDCPA and our board here and other states and other regulators, the bad apples are pretty much gone. The lawyers are preying on little bitty, non-consequential violations of the act and filing those lawsuits. So
Alleged violations.
alleged violations.
All you have to do is allege a violation, and it'll cost you $25,000 to prove it's not correct.
So if you feel in getting these applications, we're tickled to death to look at any one that you want us to do. I don't want to put the pressure. Look at all of them if you want to. I'm speaking for myself. But generally speaking, an FDCPA violation is
may establish some board policies on application review. I clearly delineate which ones need to go before the board and which ones the.
One time we had an applicant that was a mom and pop operation, and he was taking money out of his own pocket and lending it to the company to bolster his trust account, and it made him equity minus equity, but his trust accounts was okay. So those are the kind of things that we probably need to discuss and conjure over, but lawsuits for bad behavior is not.
Well, for trust issues, it is. If it's
Trust issues, it
yeah, trust
absolutely
is.
is, yeah.
But if it's FDCPA, and there are even what are the suits called where they get 50 or more people? Yeah, there's class actions where the dollar amount might be high. But if somebody sends a letter that has a bad, incorrect word in it, and they send it to 1,000, file a suit for the bad wording. And the bad wording can be determined to be shadowing under the FDCPA, which is interpretive issue. And for that, they get a class action suit. So the collection business, when the laws were put in place, it was to do what Bart said, protect against really bad actors. That's successfully done, and now the bad actors are often attorneys.
Like you told me about Harry Truman there.
Yeah.
Number 10,
Do we need to vote on that one?
we already did.
Okay.
Paladin Commercial Group Incorporated, 111, made application to renew their collection service agency license on March 10th, 2015. However, their financial statements were not prepared by a CPA or PA. Instead, they were prepared by an unlicensed PA. At the May 2015 meeting, this matter was presented to the board, and you indicated that it was required this company get a CPA and to prepare the financial statements. Tracy Knopfsinger and Dan Duncan from Paladin have written to indicate that Colorado does not require licensing of PAs, and the board has approved their application previously. See attached documents. Please indicate if this application should be approved or denied, or if there's an alternate recommendation.
If I may. Tennessee requirement for a PA, and while I don't know that this is interpreted, and you may need to interpret this legally, we're talking about if you are a Tennessee company and use a Tennessee PA, because we know what Tennessee licensing are. To have a Colorado PA we can't say a CPA has to do it because Tennessee had provided for PAs. But, and I'm asking this as well as stating it, can we say that other state PAs aren't considered because they don't follow the Tennessee licensings for PAs? An unlicensed PA in another state is a bookkeeper, and we require a CPA or equivalent. So I'd give them a big old no. They need to get a CPA, or they can get a Tennessee PA if they want.
Well-
But that really wouldn't work because they can't license, they can't practice out of the state.
Their financial statement is on QuickBooks. It's in the thing here. This is
Typical.
it's typical, and that's signed by a PA. I would think that they need to hire a CPA. There are CPAs in Colorado.
We don't know Colorado's license or laws, but if I were in another state, I could call myself a public accountant because I'm practicing publicly. I can't call myself a certified public accountant because I have a bookkeeping service and I practice for the public, so I'm a public accountant, but I'm not licensed. Colorado doesn't have PAs, to my knowledge. And so how do you get a licensed PA in Colorado? Tennessee's unique with the PA license. Not all the states had it. And it's been a problem before because someone tries to use the PA thing.
Are you
you
saying the PA system is not working?
Where in the statute does it say that?
It's in the part about licensed public accountants and certified public accountants is in 6220-106. Subsection 2, it says an application for a collection service license shall be submitted on the form prescribed by the board and shall be accompanied by subsection 2, a current personal or corporate financial statement prepared by a licensed public accountant or certified public accountant. I mean, our rules clearly say licensed public accountant or CPA.
If your state doesn't license public accountants, then you need to get a CPA.
Yeah.
I'd entertain a motion that we deny that application and inform Paladin and give them plenty of time to get their CPA.
Second.
All in favor say aye.
Aye.
Aye. Number 11,
Harvard Collection Services Incorporated 1195 made application to renew their collection service agency license 2015. However, their financial statement included a qualified opinion. Please see attached documents. As a matter of policy moving forward, does the board want financial statements that include qualified opinions to be reviewed by the board, or shall we process these applications administratively? Please consider creating a policy on this matter. You need to look at that one for me.
I,
That one was brought to me by Bill Huddleston, because I
Be the nature of the qualification. If it's a going concern qualification, then they do have a CPA doing it, but we have under other areas of the statute, it depends on the nature of the qualification. And the nature of the qualification will be at least vaguely stated in the accountant's report.
our statute doesn't say anything about a qualified opinion.
No, it doesn't. It
I
just
think
says the
it's prepared by
CPA
a
prepared.
licensed PA and a licensed, or a CPA.
Well, please remember, I am not
No.
CPA.
If in the report it says we're qualifying it for going concern issues, then that means that they may not be in business, that they're shaky. Okay? Now, that could also mean that they have substantially violated GAAP and the accountant doesn't like it. But if it's simply a GAAP violation and someone's taken a position contrary to GAAP, I mean,
She doesn't know what GAP is, and it's too much.
Do
but
actually.
it says it in the report. It'll say in the report what the reason is. But I don't know that we can actually deny it for a qualified report.
Those are your professional standards.
Yes. But it does go to the other section we were talking about earlier.
I'm all over it.
You're gonna do fine.
That,
Are you saying then that it's okay to have a qualified opinion?
under 6220-107, number 3, who is not financially responsible. Okay, a qualified opinion can imply a lack of financial responsibility under a going concern. It means that they may or may not make it. But if it's simply a gap issue, if it's an argument over a presentation issue that they're qualified for, and you can be qualified for that, then that doesn't have anything to do with financial responsibility. We're worried if they're not going to stay in business and pay the trust money.
So I hate delaying anyone's application, but
what the report says.
but actual application is probably sitting about 6 inches in front of you, so you'd probably be faster to just
I
grab it.
know Harvard Collection Services, and they are a well-qualified agency.
It is a renewal, so it'll be a white one.
Whoa, wait, hey. I know. It's gonna be fun. Bye-bye.
Basis for qualified opinion is fully described in Note 1. The company's financials do not include the accounts of 39 Edelston that the company has determined as a variable, it's a VIE. So they're qualifying, in which the company holds a variable interest in the primary beneficiary. In our opinion, the company's statement should include the VIE to conform with accounting principles. Okay, we're going to territory if we go
Calm
in.
that down for me.
The VIE is a
That's too
variable
much.
interest entity. I'm going to make it very brief. And a variable interest entity is an off-the-books company that you finance through. The accounting firm says that they should consolidate the VIE.
Okay.
And the company says, no, it's not consolidated. Now, what we don't know is, what is the effect of not consolidating the VIE? If they've moved all their liabilities off books, we just don't know. And without further inquiry and pretty deep inquiry, we can't tell, and we really are not in a position to make a judgment. Boy, that's an interesting exception. Only suppose, and that's not our job to suppose. We should. For our rules, if they have positive equity and they're in trust and they have an accountant certified to the information, then we pretty much pass them. Looking them internally, if they consolidated, would it throw them into negative equity? We don't know. I don't know what the hell. CPA to report on it. Our rules don't say what kind of report.
So
I wondered if, since this is a renewal,
Question is solvency. We simply don't know if the VIE consolidated entity, which they're reporting on, and thank goodness it's a parent that's reporting correctly, could it be thrown into a negative equity situation because of whatever assets?
I'm just wondering if I don't know about all these words. In my mind, I'm just wondering if they currently meet the financial. I mean, how far, I guess, can we go into the what ifs?
that's kind of where
Yeah, they currently meet it.
Right. But I mean, I don't, you guys know way more about this than I do. I'm just throwing that as a thought.
We don't require an audit report.
No. And I intend to
We accept a
approve this
compilation.
application because I know this agency and I know they're very well qualified. But more than that, I think what we're trying to do is streamline our effort
Right.
in Nicole's position to make
Right.
decisions based on this. VIE, I knew what a VIE, but I've suppose when you get one of those, it should come to the board and we should discuss it at that time. We can say all
Because
that.
it's written in
Yeah,
there.
yeah.
It's okay. It's okay.
I'd second the motion, and if I may make a comment, had they requested a compilation report, the question of a VIE would not have come up, and a CPA would have signed off meeting our standards under a compilation report. So the fact that they had an audit report and they gave an exception because of not including the VIE, and we don't know what it implies. The only place we can go, in my opinion, is solvent, because we don't have an answer to that. But that's so speculative that, they had a CPA sign.
Motion's been made and seconded that we approve.
No.
I'm sorry, I
I
was.
was waiting for him to.
I'm
Stop,
sorry.
yeah, thank you.
You said I'd second, but I'll make a comment.
Yeah.
I almost did.
So, Harb does
My
the.
motion is to approve it like Bart said.
All in favor, say aye. Aye. Okay. Number 12.
And then the general direction from that I also took is that if they have
Qualified opinion.
qualified opinions in them, still take them to the board because I'm probably get your expertise on
If it
these.
says going concern, that's
Definitely.
something we'll have to look at.
Okay, definitely, I definitely got the going concern thing, but there may be other things that I still don't know. So I think just generally, qualified opinion should still come to you.
I wonder if we could ask them for a compilation report prepared by their CPA.
It's still not gonna have the VIE included.
Let's just trust, and then if they go sour, we can always go back and. The last one, yay. In my short time with the board, I've seen a few examples of this for consistency. This is the general thing we've already started talked about. The board developed a policy on this. We've seen occasionally the parent subsidiary relationship and the parent financial documents submitted inconsistently be either just the parent company or the CPA's independent financial statement will be the parent company, but the board's financial statement form will be the subsidiary collection agency. How would you like staff to proceed? I think you've indicated that you want it to be the subsidiary or the specifically the collection agency's financial information. Here's the examples that I brought today. There were more of them. Although many of them have been approved, and I think we're going to have to do some kind of press release on this or something or newsletter article or something, because there are a lot of current collection agencies have been submitting applications of their parent companies. We're going to have a history of people who have applications and renewals that got through previously, and next time they come around, they're going to be really unhappy. I just want to make sure you know that.
Just reflecting our state.
But, so the applications in front of you are 1828, True Accord, 1477, 1506, 1507, 1508, 1509, 1510, 1511, which are all the receivable management company, and 1870, 1871 DT Credit Company LLC. That's that big stack.
First of all, I don't think that we should penalize these folks that have always sent this sort of application, financial statement in, and we've approved it in the past, in delaying their approval. Have to delay their approval, but I think a kind letter say the board has taken the position that that the entity has to be prepared to verify trust matters and solvency and so forth, and it's not that difficult for them to do that. They can break the numbers out and make the financial statement.
Compilation report by a CPA is a signed CPA report saying here's the numbers of the company, and that meets our standard. We need to let them know we don't require an audited report. Now, they can go to their CPA and say, I want a compilation on this subsidiary, and they can do it with or without footnotes. Now, we don't need to tell them that, but if they're smart, they'll just send us a compilation with no footnotes. That's pretty much,
Yeah.
I
don't think it's going to be that difficult for them to do it that way. They're just going to have to change their internal.
licensing hurdle that they should meet.
We'll create a new benchmark, and we'll move forward with this policy.
Vote.
Yes, I do. I guess these applications will be denied because
Art said to approve them.
No.
Or are we going to deny them?
We approved one, but we're not going to. I hate to use the word deny the applications. I think ask them for a compilation report on the collection entity that you. I don't want to sit in your spot when you start getting the phone calls.
they're already pending applications. I mean,
Yeah.
they're already incomplete.
They're already incomplete, aren't they?
Yeah. A lot of these have been sitting out there for quite a while. You can see it on that fancy colored document, the applications that are pending.
Yeah, I think we ought to skin the cat and get it started.
Yeah, to. We just
blank
don't-
pages,
yeah,
but,
now's the time to do it.
Yeah, might as well.
so you can, and the ones that are pink are expired. All of those people have expired. So all those people are, and I hate to hope it, I hate to think it, but I hope they're not practicing. There's a
mean-
lot of those numbers.
Can I make a comment?
Mhm.
Sorry. It's all, it's always an option if you don't just outright want to deny these people out of the gate here, since we're kind of trying to figure out, wading through the waters of, you can always just do what you suggested. Send a letter. Say this is what, we just are requesting more information. To just outright deny them and just request more information and then go from there.
That was my intention, rather than deny their application. And I see the ones in pink, most of them have expired, but I think there's a 6-month statute or something on, statute of limitations on that. So a lot of these are still in business legally. But we can do that rather than deny delay. Is that fair? Or
I mean, I think
request
it's fair,
additional-
since
request
we're
additional
sitting here having the
information?
discussion of how we're going to approach this from now on. I think it's fair this go round to just send a letter and request more information. In my opinion, I mean, you're certainly welcome to do whatever you want.
I think that's excellent.
And you can see also on that colored report, you can see which ones, the ones marked in blue, actually tell which ones are which. I marked them so that it would be
That was
obvious.
good. That was a good move.
You're going to have applications that are new applications that don't have a trust account. Or they may have a trust account, they have to have a trust account, but they may not have any money in it because they don't owe anybody any.
I've seen lots of examples of that
They
already.
could have been practicing in another state and just apply for us, and they've been
Initial
collecting
ones a
for
lot.
years. Or they can just be opening in Tennessee from the beginning, and they wouldn't have a trust account then. Yeah, it's going to be
There are
different.
10 in that category, a parent subsidiary.
Are we okay then? Is that,
Yes.
we know what to do? I think that's fine.
I think
Yeah.
that will work. Vote if you feel like it's necessary.
If you would rather have a vote, Nicole, we'd be glad to.
Do it either way. so-
Okay. Then let's not vote.
Okay. Direction pretty well. All right. All right, so just after that is the surrenders. I included the budget information, the detail breakdown.
Legal report. I think rather than, I mean, in the past, or last meeting at least, we asked you to read them. I'm better not reading them as long as I'm confident that they're going in the record.
It's just, we have to read the actual complaint numbers into the record, but if for some reason you don't want to read the complaints in their entirety, I mean, we can kind of just go through that way. To be honest, in all of my other boards, I do read them all into the record word for word, but it's really up to you guys.
I think I just want to make sure that the actual complaint
Number.
is, well, not just the number, but the complaint
Okay.
is in the record.
Okay.
So what's wrong with this
Please, how do
company?
we get to the page?
Okay.
So, and if it's done without you reading it, then that's okay.
That's where the little file is.
But if it's not in the record, unless you read it, then then you should read it.
Right, the legal report itself does go into the minutes in its entirety, so.
Let's go ahead and read them today, and let me think of that.
Okay, yeah, just think on it, and if we need to switch it up after this and kind of just do more of a summary, we can
Yes, please.
get geared toward that. Okay. The first item that we have several complaints, so I'm going to read each of those numbers into the record. It's item 2015007071, 2015007081, 2015007111, 2015007121, 2015007131, 2015007161, 2015007171, 2015007231, 2015007391, 2015007401, 2015007411, 2015007431, 2015007441, 2015007451, 2015007481, 2015007541, 2015007551, 2015007591, 2015007601, and 2015007641. These complaints were opened by the administrative staff of the Tennessee Collection Service Board for failure to timely submit proof of a current surety bond coverage as required by law. Subsequently, after being notified by the board that coverage had expired, the respondents in these matters complied by sending proof of current surety bond coverage to this office. Recommendation is to dismiss. Do you want me to we're going to go all the way through?
We'll vote on them at the end, yes.
Okay. Item 2, there are several on this one as well. 2015007091, 2015007101, 2015007141, 2015007251, 2015007271, 2015007361, 2015007381, 2015007461, 2015007561, 2015007581, 2015007621, 2015007651, and 2015007661. These complaints were opened by the administrative staff of the board for failure to timely submit proof of current surety bond coverage as required by law, despite this office's attempts to contact respondents via certified letter, telephone, and email requesting a current bond. Respondents in these matters failed to submit a response and are currently without proper surety bond coverage. Recommendation is the authorization of a civil penalty in the amount of $250 for failure to timely provide proof of current surety bond coverage to the board, plus proof of current surety bond coverage to be satisfied within 30 days of execution of the consent order, such terms to be settled by consent order or formal hearing.
Okay, and then if they don't provide the coverage within 30 days, then can you administratively revoke their license, or how would that happen?
No, I think the way this is set up, if we're going to ask for proof of the current surety bond coverage to be satisfied within 30 days, if we don't get that coverage, then it would just move to a formal because they haven't satisfied the terms of the consent order.
And then at the formal, that's when we would revoke
That
their
would be
license.
when you would seek the further action. Right. Okay. Item 3, 2015007151, 2015007371, 2015007491, 2015007501, 2015007571, and 2015007671. These complaints were also opened by the administrative staff of the board for failure to timely submit proof of surety bond coverage. Subsequently, after being notified by the board that coverage had expired, the respondents in these matters opted to voluntarily surrender their licenses. The recommendation is to dismiss. Okay, item 4, 2014-025181. This complaint alleges respondent failed to provide validation of the debt within 30 days of the request as made by complainant's attorney. Complainant has requested the removal of the trade line from his credit report. Respondent sent a response stating that it is a passive debt buyer. Although it does not initiate collection calls or generate demand letters, it places accounts for collection with its network of branch offices. The account at issue is a charged-off consumer credit card account. Respondent purchased the account on or about April 23, 2014. The balance owed on the account at the time was $7,741.70. Respondent stated the account was placed for collection with the attorney's office on May 2, 2014, and an initial notice letter was mailed to complainant on or about May 2, 2014. On May 19, 2014, the attorney's office received the consumer's request for verification of the debt. The attorney's office notated the disputed status of the account, requested additional account documentation from respondent, and placed a hold on collection activity pending the receipt of such documentation. On July 29, 2014, the attorney's office mailed verification of the debt to the consumer in compliance with the law. Respondent stated that contrary to the consumer's assertion, the Fair Credit Reporting Act does not impose on debt collectors a 30-day deadline to respond to requests for verification of debt. Thus, the July 29th response to the complainant's request was timely. Respondent stated it has reported the disputed status of the account to the credit bureaus, and the account has been transferred to another agency for collection. Due to insufficient evidence of a violation on the part of respondent, counsel recommends this matter be closed with no further action.
Okay.
Item 5, 2014-032291. This matter is being represented from the May 2015 meeting, at which time the board authorized a civil penalty in the amount of $500 for failure to respond to the complaint in violation of TCA 6220-115A3 and 6220-115B4. The facts as presented at the previous meeting are as follows. I don't know if you guys want me to read those since this is the second time you've seen them, or if you just want to take a second to glance over and refamiliarize yourself. Okay. Okay, so I'll just tell you what transpired after the fact. So after the consent order was sent to the respondent, this office received correspondence from respondent that it never received a copy of the complaint and thus was not given a chance to respond. Legal staff consulted the file, and it appears the complaint was never forwarded to the respondent for response. Subsequently, respondent sent a response stating that it never received the complaint and its records do not reflect receiving notification from complainant to validate the debt. Respondent stated it has policies and procedures in place to immediately validate any disputed debt once notification is received. Along with the response, respondent sent a copy of the letter dated May 28th that it mailed to complainant, stating it is in receipt of complainant's dispute letter regarding complainant's account. The letter also states that respondent has verified with its own client that the charges are true and correct. The recommendation on this one is to dismiss, and it's because the reason that they got the civil penalty in the previous meeting was because they failed to respond, and then when we checked the file, unfortunately, it didn't get sent to them for a response. Okay, item 6, 2014026781. This matter is being represented from the March 2015 board meeting, at which time the commission authorized a $4,000 consent order against respondent for violations of TCA 6220-115B5. The facts of the matter were presented at the previous meeting as follows, and in the italicized words there, I have the way that the complaint was set out at the March meeting. Again, if you want me to read it, I can. If you want to just look back over it and
Let's just give us just a moment to
Okay.
read through it.
So, after the consent order was sent to respondent, Office of Legal Counsel received information from respondent and its attorney that it never received the initial complaint and was not given a chance to respond. This office did receive a certified mail green card showing that the original complaint was signed for as received by someone at respondent's office. However, respondent stated this person never got the complaint to the correct person within the office, and that's why it was never responded to. Respondent also stated the person responsible for the miscommunication is no longer employed at respondent's office. Respondent attorney did send a substantive response to the complaint after the issue was discovered. In that response, respondent stated it wanted to apologize for not responding sooner. The lack of response was not intentional or due to any lack of respect. Rather, it was due solely to an internal problem in the corporation's mailroom. It was an isolated incident and will not happen moving forward. The employee responsible for the problem has been terminated, and special instructions and procedures have been implemented to bring regulatory correspondence to the immediate attention of the compliance officer. Respondent also stated that complainant's complaint is based upon allegations that respondent ignored letters of representation from legal counsel on behalf of complainant. However, respondent states, according to its records, it never received any written notice of representation from legal counsel. Respondent stated it spoke with complainant on 3 different occasions in May 2014, in which she expressed she was attempting to work with the medical provider regarding the charges. On June 1, 2014, respondent received a letter from complainant asking if the charges could be filed with her new carrier. Respondent stated that in a good faith effort to resolve the events surrounding the matter, respondent assures that complainant will not be subjected to further debt collection efforts for the $191.41 by the respondent. Respondent has requested that the creditor also cease further collection efforts regarding this debt. And my recommendation in this matter is to just have discussion on this one, because I just wanted to get your all's feedback on what you think about this.
The original complaint was that the debtor continued to request, and the debtor's lawyer continued to request that for a validation or verification of validation of the debt on 4 different occasions or more, and they never did that. Are they saying now that they didn't get that letter from the lawyer?
Right, I think that in the response, they were stating that according to their records, they'd never received written notice of representation from complainant's counsel.
But they did receive the notice and was signed for, but never got to somebody. They got the green card because somebody signed for it.
Yeah, I think that's 2 different things. I think he's asking, what he's saying is the respondent claiming that they didn't get notice from complainant's attorney saying they were representing complainant and asking for verification of this debt. The other issue is we have the certified mail green card for mailing the complaint for a response, and that was signed off on. However, unfortunately, whoever was working in the mailroom at respondent's location didn't get the complaint to the correct person, so they weren't able to respond to it because it just never got where it was supposed to be, and then subsequently that employee apparently was terminated. So it's two different, I think you guys are asking two different questions.
First one, they never actually heard from counsel that they were being represented by
That's-
counsel?
Right, that's what the respondent is stating. They never got correspondence from complainant's counsel saying that they were representing complainant and that they were requesting this verification.
Given the mailroom activity, we don't know that it didn't go to the same person in the mailroom and it just never got sent.
That's true.
Did I read in here somewhere that you had tried to call?
I did, and I have been in touch with him since then. So, right.
How do you feel about it?
Well, I feel
I don't
like
wanna- I
he's
don't wanna-
making a valid statement and saying that if this happened with the information that we sent them, certainly something could have happened from complainant's counsel sending something in.
We don't get to let them get off light just because they're irresponsible. I mean, if they have a bad mailroom employee, who else in their company needs to be fired because they're not paying attention to what they're doing? That's not for us to decide. You know, maybe we reduce the amount, but I still think they should be censured and or penalized in some fashion because they mess up. And why didn't the attorney call you back the first time? Did he ever say?
I'm sure that he's just busy and had things going on. I mean, they don't call you back immediately, normally. But I have spoken with him since then, and we have had.
Tell you that he sent these letters requesting the verification?
Hold on one second. Let me make sure we're on the right page here. Yeah, I did. Yeah, I think you guys, when you're asking about the attorney, this was complainant's attorney that didn't respond, not the respondent's attorney.
Yeah, I understand.
The respondent's attorney has been very responsive.
But the complaint,
Yeah, the
The-
complainant's attorney who apparently supposedly sent this letter saying, I represent this person, was not responsive when I contacted
Not
him.
responded at all?
Correct, but the respondent's attorney has been very responsive.
Then we don't know that the attorney really exists or really did the
Correct,
job.
and I apologize. I think I misunderstood which attorney you were speaking of.
The debtor could just be alleging they had the
Yeah.
attorney do it, and the attorney's like, I don't know.
Exactly.
yeah.
Well, I believe there are copies of those letters in the complaint file, so we do have proof that the letters existed.
Sent and received.
We don't have proof that they were received, to my knowledge. You can look through there and see, but I looked again before I came, and I didn't find proof that they were delivered. But if you'll give me 1 second to let me make sure that that's correct. I apologize. I just need 1 second. It looks like from the information in the file, the complainant's attorney's letters, it looks like they were only sent U.S. mail. We don't have actual proof that they got where they were going.
U.S. mail is trustworthy and fair enough to believe that it.
Right. We just don't have the information in the file saying, like how we have the certified green cards, we don't have the information saying it was delivered, signed for, or anything like that.
That attorney never responded to you at all.
Correct. The complainant's attorney did not respond. At all. And they still haven't, so.
That makes me wonder was, I don't doubt the attorney was real and have sent the letter, but did she ever really engage the attorney, and the attorney ever accept an engagement? Was the attorney?
That's what occurs to me too.
The attorney's letter to the collection agency. I wonder if the collection agency, anybody at the collection agency ever saw the letter.
The debtor's
That's not-
attorney sent a letter to the collection agency?
Yes.
Yes, the complainant's attorney did send the
Oh.
letter. We just don't have, I guess, proof that it actually got where it was
4
going.
times.
Okay, well, then that means she was represented.
Yeah.
Okay, so I'm back to square one now, which is just because they can't do their work right doesn't mean we should be nice to them. That's just kind of. That would imply something that we need to be concerned about, that the agency is internally doing a good job, which is, you know.
I personally think that it ought to stick.
I concur.
Right, we have to keep in mind too that one of the violations at the past meeting was for failure to respond. So if you, right, if you see that, you need to perhaps reduce it because they now have responded and there was an internal error, then that's something to consider too. Because
Still
we,
fail to respond.
right,
3 violations for failing to validate the debt. And so that would be at $500 apiece, would be $1,500.
Yeah, but they still get the censure. They still get the warning of, that goes along with the violation.
Yeah, along with the consent order and that sort of thing, yeah.
right. I mean, if you're just, asking to reduce, they would still get a consent order. It would just be amended to reflect the new penalty that you guys authorize. So basically, the same thing would be happening. It would just be for a different amount, if that's what you want to do. But can you? Oh, sorry, we're not finished. We need, I think on this one too, we need to make sure that when you're making your new recommendation, we kind of need to itemize what we're penalizing them for and get an amount so that it can be clear when I'm doing the consent order. To the respondent as well.
Kevin?
Did you want to just keep moving before we try to break
You
that?
just
one
go
down?
ahead and do this one right
Wanna vote
now.
on
Yeah,
this
maybe
one now?
let's, while it's
Yeah,
fresh in
let's
our
just shoot this
minds,
one and-
let's
yeah.
do this one and then we can go back and start down the list again. I think it's better while we've got this fresh on
There
our
you go.
minds.
I'd entertain a motion to reduce the fine to $500 each for the failure to verify. Bond for a total of $2,000. Failed to verify 3 times, didn't he?
I think it's twice.
Well, then twice at $500, and then one time for failing to. Is there a motion made?
So moved.
Second.
Motion made and seconded. All in favor? Aye. Okay.
Okay, hold on one second. Let me just get this written down. Okay, she got it. Never. Okay, we'll move on to item 7, 2015007701. This complaint alleges respondent came to complainant's place of employment in January 2014 to serve complainant with a garnishment notice. The complaint alleges that respondent never spoke directly to or made an attempt to speak to complainant, but gave notice to other people who were third parties, as well as provided personal and private information regarding complainant to those third parties. Complainant also alleged overpayment to respondent. Respondent sent a response to the complaint stating that it has had several conversations with complainant and complainant was served a warrant and garnishment. Respondent stated complainant agreed to pay $50 per month and there's no overpayment on the account. Specifically, respondent stated that in January 2014, a process server came to complainant's place of business in an attempt to serve him with a warrant, not a garnishment. Respondent stated that complainant appeared to be confused about which documents were delivered in January 2014 versus September 2014, which was when a garnishment was issued. Respondent stated complainant did, in fact, sign for the warrant. In September 2014, the County Sheriff's Department came to complainant's place of business to serve a garnishment on his employer, which is proper. This is not a violation of third-party disclosures. After the respondent sent a response to the complainant filed an additional response stating that the garnished notice was improper as it was not delivered to his employers that would have needed notice, but it was instead delivered to supervisors that have no role in mandating any collections and no authority to make decisions. The recommendation in this matter is to dismiss. Item 8, 2015009321. This complaint alleges respondent failed to give complainant credit for the payment she's made. Respondent sent a response stating that the payment complainant paid on December 29, 2014 was paid to a different medical group rather than the one respondent is collecting for. Thus, respondent stated this complaint is unfounded and there were no violations of any federal or state collection laws. It appears from the documentation in the file regarding payment by complainant that complainant did make at least one payment to a different medical group rather than the provider that is the client of respondent. Thus, there is insufficient evidence of a violation on the part of respondent. Council recommends this matter be closed with no further action. Item 9, 2015009381. This complaint alleges that respondent violated the Fair Debt Collection Practices Act. Complainant alleges that he mailed respondent a request for proof of contract regarding a debt that his insurance company may have erroneously paid. Complainant stated that respondent was unable or unwilling to provide such evidence. Complainant also alleges that respondent used his incorrect name and address, and complainant demanded that they be removed. Respondent sent a response to the complaint stating that in December 2014 and March 2015, respondent received letters from complainant disputing two separate accounts. Subsequently, the two counts were withdrawn from complainant's credit record. After reviewing complainant's complaint with the board, respondent has closed and returned 24 accounts to its clients and requested all accounts to be withdrawn from complainant's credit record. Recommendation is to dismiss. Item 10, 2015013161. This complaint was filed alleging that in April 2015, complainant ordered all of her credit reports as part of her annual review. On this date, with Experian, respondent stated she disputed that she was ever treated at the medical provider for which respondent was attempting to collect a debt. Complainant alleged that respondent listed incorrect information on her credit report. Complainant stated that the date the collection was opened was March 2012, and it was disputed in November 2012, but remained on her credit report. Complainant alleged that she spoke with a representative at respondent office. However, she was informed that the case will remain on her report. Complainant also alleged that she contacted the medical provider to get a copy of her records and was informed they have no record of her being treated there. Complainant stated even the medical provider had attempted to contact respondent on complainant's behalf but was told they could not give her information because of HIPAA. Complainant wants this information removed from all the credit reporting agencies. Respondent sent a response outlining the timeline of events. According to respondent, on March 1, 2013, its client, the above-mentioned medical provider, placed an account with her office for collections in the amount of $136.35. The account listed complainant as the patient and the guarantor. The account listed the date services were rendered as September 9, 2011. On March 2, 2012, respondent stated it mailed an initial notice to complainant which included the necessary information concerning the debt and rights under the Fair Debt Collections Practice Act. On March 4, 2012, complainant called in and disputed the account. The account was noted as disputed and reported to the three major credit reporting agencies as disputed. On November 10, 2013, the account was withdrawn from the three major credit reporting agencies. On May 6, 2015, complainant sent an email to contact her concerning her account, and complainant was contacted by respondent. On June 1, 2015, the account was closed and returned to complainant. All collection activity on this account has been ceased. On June 2, 2015, respondent confirmed with the three major credit reporting agencies that the account was withdrawn. The recommendation is to dismiss. Item 11, 2015010271. This complaint alleges that complainant attempted to pay on a debt owed. However, after 3 to 4 business days, the check was canceled because she typed a number incorrectly. Complainant states this was not due to a bounced check or insufficient funds in her account. Complainant stated that as a result, she began getting unpleasant phone calls from respondent up to 4 to 5 times a day. Complainant stated that eventually she changed her phone number and checking account number. Complainant stated she attempted to resend the money from the same account, however, the bank informed her she did not owe any money and that the respondent should not be calling her. Complainant alleged that respondent is a fraud. Respondent sent a response to the complaint stating that complainant's account has been closed in all of respondent's systems. Respondent regrets any confusion and inconvenience that complainant may have experienced as a result of this issue. Recommendation is to dismiss.
So this agency attempting to collect a debt that it didn't, that the respondent didn't owe. Respondent is trying to collect a debt that was never the complainant's debt.
Are we just talking about item 11? It was my understanding that they were attempting to collect a debt that she did owe, but because of something that happened with her check, they
Oh, I
continued,
see.
right, they continued to call her over and over even after it had been settled. But then once they figured out what the issue was with the check, then they just closed it.
Okay, good report. Are there any corrections or questions on any of the complaints other than our number 6, and we've already resolved that?
I have a
Real disputes, yeah, the agency should
Absolutely.
take
It's-
better care of their business. And most agencies do take
I
better
know,
care of their
but
business.
I feel for,
Right.
I
It
mean,
seems like a process.
absolutely,
Mhm.
that took that.
Number 10, it's incidental, but I think it should be corrected. In the second to the last sentence of your, of the respondent's response,
Uh-huh.
the account was closed and returned to complainant. I think it should be client.
Okay. We'll make that correction before they get posted to the minutes.
Motion that we accept the legal report as, second.
Second.
All in favor?
Aye.
Great.
Thank you.
Is that it? Is there any other business?
Ellis,
Oh,
Keeling has one more.
That slipped my mind, and I apologize. I can't imagine how, but it did. I received a letter. Oh, it's on the iPad. I'm sorry. A letter from an attorney, and I guess you guys have it in front of you.
yes.
He has contacted me several times, I guess, to try to get clarification on these issues that are stated in this letter. And a lot of times the intricacies of what they're asking me are a little outside my realm. And I feel like I need some guidance from you guys since you're actually in the industry. Some of this is like a foreign language to me. And I don't want to give them advice on how to run their business when I also don't run this type of business. So I just wanted you guys to just kind of glance over. He's given us 2 hypotheticals toward the end of the letter. And I think these are the 2 questions that he's really trying to wrap his mind around. And if you guys could, maybe we could just go through these 2 and see if we could get going in some direction of a response that I could give to him about your thoughts on this. That would be really helpful to me.
know if the money that's collected is sent to the affiliated, or to the affiliate all the money directed, or is the affiliate, what they do is they may have and I'm just assuming that they may have a call center in a different place that they do collection work and have all the money sent to the home office.
Right.
Is that what you think that is?
I didn't ask that question specifically. I'm trying to recall my conversation with this person. I think that he is posing the question the way you just stated it. I believe that is what's going on.
My opinion is, and the other board members may differ with me, if they have a branch license, and they're doing call center work from that, directing the money to be sent to the home office.
Okay. Okay.
If on the other hand, he's using the affiliates as an
Calls being made under
the
agency,
agency.
affiliate, or the branch that's making the calls is
Off-site call
an
center.
off-site call center for the company, but it's actually owned by someone else. The fact that the affiliate provides the people is a relationship. I mean, if you hired somebody from a temp service and they came in, the temp service doesn't have to get a license.
Right. It makes sense when you say it, but when I'm thinking about it, it doesn't make a bit of sense.
Because that lawyer.
Yeah. Yeah.
Okay.
They're basically a temp service.
Vote on that?
No, I just needed to get some information so that I can respond to him and make an educated response.
Are there any other matters to come before the board?
No, sir.
Great job, Nicole. Great job, Keeling. Thank you very much. Motion second and third? Okay, fourth. Nice to meet you.
Pleasure, sir.